Till we leave the European Convention on Human Rights, get it out of British law, leave that ludicrous foreign court, we will have criminals from all over the world making a total mockery of this country.
Gawain Towler is a former advisor to Nigel Farage, a leader of Reform UK, the Brexit Party, and UKIP. Thanks for coming on the programme, Mr Towler. Your former boss referred to there as criminals who were being blocked from being deported. This is rather different, though, isn't it? This isn't a criminal.
Well, he wasn't referring to this case, was he?
No.
That's a clip from before this case. It was a bit rich to say he wasn't. Of course, he wasn't. He was referring to other things.
Well, he'd leave the ECHR anyway, regardless.
The bottom line is we need to leave the ECHR. It was interesting to hear what Catherine was saying about how every other year we can make a new Immigration Act and then it falls foul of the ECHR. The easy way to deal with this is to have a government making decisions, having been elected, on a policy, and that is it, rather than having a foreign court dictating what that policy may or may not do. We are a democracy. The democracy requires that our courts do what they're told by our legislators. That's what sovereignty means. And so, whilst we can be humane, there is no reason, and this is an interesting case. I mean, as you pointed out, these are not cheap things that are going on here. They're not being paid by the taxpayer. We agree. This is a private medical. But the idea that there's nowhere else in the world the two of them can meet has got to be for the birds. If they can afford that sort of medical treatment, then I'm sure they can go to Switzerland. I'm sure they can go to
but you can
Egypt.
Understand.
If she can get out of Gaza, then why on earth does she have to come here?
But we can understand, can't we?
You can go elsewhere.
We can understand why, if you're living in the UK, you might want your grandmother or your mother to come to the UK. That's reasonable.
I can understand why she might want that, but I can also understand the frustration of a Home Secretary that is hidebound by the ECHR membership in Article 8, saying, hold on, you mentioned precedent. One of the weird things about the ECHR and European law, as it is applied within the United Kingdom, is their law is not precedent-based, ours is. But once you have decisions made by British courts based on a non-precedent court, they become precedent in the UK. And so, therefore, lower courts will be able to use this decision to allow more people in, who the government feel are not suitable, or that precedent is made. So it's not an individual case. Every case that's made by our courts becomes a precedent. And thus, your concerns that you mentioned and the Home Secretary's concerns are real. The Home Secretary, of course, has a way around this and can cut through the Gordian knot and leave the ECHR. And also large chunks of the Human Rights Act, which bring the ECHR into our system. So there is a way around it. There is a way of solving this problem, of stopping these ghastly headlines time after time after time. But that's to bite the bullet.
One of the things that people raise in objection is, the ECHR Human Rights Act guarantees my human rights too, guarantees my protections as well. If you do away with that, you're doing away with my protections.
You've got this daft idea that before the Europeans gave us the European Court, we had no rights.
We were involved in it.
Of course we do. We have our legal system. We have the common law. We have 1,000 years of the development of human rights within and liberties within these islands. The idea that we need a bunch of foreign judges to tell us what is a human right or what is our liberty is ridiculous. You know that. I know that. Everybody knows that.
Good to speak to you. Gawain Towler, former advisor to Nigel Farage, as leader of Reform UK, the Brexit Party, and UKIP. You can understand it, just on a purely human level. You can understand why you'd want to get your family member out of a war zone. Why, two, if you're in the UK, you'd want them to come to the United Kingdom, and if they need medical treatment, they can have private medical treatment. You'd do the same, wouldn't you? You'd want to do the same. If the government has a policy that would stop you from doing that, is it right that the court overrules them and says, yes, because the right to a family life is sacrosanct, this woman can come to the UK regardless of what the government says? This woman is coming genuinely to access medical treatment as a visitor. The court says we find that she does not want to settle permanently in the UK and that the application for private medical treatment is a genuine application. It's difficult to get on the plane back home, isn't it? To go back to Gaza after that?
Lots of the cases that we've heard about have been about attempts to deport individuals who've engaged in criminal activity. Now, of course, this case, the facts are obviously infinitely more sympathetic. A woman from Palestine with all sorts of health problems, with a daughter who is already here. This case wasn't just a first instance decision; it gone on appeal, and although I've not seen the judgment, it's been looked at twice by the courts, and they've clearly decided the mother is entitled to come and indeed to get the treatment. And this is under Article 8 of the European Convention on Human Rights, which is the right to family life. However, the right to family life isn't a trump card. It's what's called a qualified right, and that means that it's read subject to public policy considerations. And what the decision maker, the initial decision maker who acts on behalf of the Secretary of State, and then ultimately the courts have got to do, is to balance the individual interest of coming and the state interest about trying to control immigration. And they've obviously decided in this case that, in fact, the individual interest prevailed over the state interest.
The tribunal ruling saying, we find that the refusal of entry clearance amounts to an interference with this family life because the sponsor is physically unable to visit her mother in Gaza to develop their family life in that country, and it is not suggested that during the current time they could spend time together elsewhere. So yes, there is the medical procedures that are being undergone privately, so £55,000 we're told, which is a lot of money in medical fees, so it's not like they're happening on the NHS. But would this, in theory, give people the right to reunite with family members in the UK from anywhere where there is conflict around the world?
Well, that's clearly what the Secretary of State is concerned about. But what you've got to remember too is, as I say, the state has got an interest in upholding its own immigration laws, and the courts are very well aware of that. What is possible, and what the repeated Home Secretaries have done, is to pass legislation to make clear what are the contours of when individuals can come and when they cannot. And therefore, what the Home Secretary can do is can pass further laws. There's probably an immigration law most years or every other year, clarifying exactly the circumstances in which the state will accept individuals to come in. Now, of course, as we know, it's very difficult for individuals even to leave Gaza. So the idea that there's going to be some sort of flood of individuals coming from Gaza is extremely unlikely.
But, okay, can I ask a better question, Catherine?
Go ahead.
Why wouldn't it grant anyone that right to be able to come to the United Kingdom, seek reunification with their family from a war zone?
Well, I mean, that's obviously what the Secretary of State's worried about. Now, of course...
Because it would, wouldn't it? I mean, if this ruling were given broad application, if you're in a war zone anywhere around the world and you've got a family member in the UK, you could apply.
Well, absolutely. And of course, you know, you and I would do if we were in the same circumstances.
Absolutely, of course.
But the problem is, of course, from the state's point of view, from the Home Secretary's point of view, that's what she's worried about. Now, all states have got limitations on when people can come in, and it's up to the Home Secretary then to try and tighten up those limitations. However, if the Home Secretary goes too far, they can still be trumped by Article 8 considerations. That's Article 8 of the European Convention. So it is a balancing act. But yes, of course, it's a really very difficult situation. But this is the family reunification of citizens of good character is much less controversial than the issues about deportation of people with bad character.
Catherine, appreciate it. Professor Catherine Barnard, Professor of EU Law at the University of Cambridge, Fellow at UK in a Changing Europe. So does this make the argument further to leave the ECHR?